Once persons are arrested and put in custody, whether it is from the United States of America requesting or any other country, our laws in this country do not stop operating. In fact, we are much more alert when foreigners are asking for our citizens. I have looked at the application that has been brought before you, Your Honor. Currently, it's not an extradition request. It's an application to ask for persons to be held in custody while investigations are going on. It is something I think the prosecution must have forgotten to tell you that they are saying they want to investigate. If then they want to investigate and they have come under Article 49, 1, G, and F, and also under Section 36 and 36 of the Criminal Procedure Code, 36A, things come into play. The fundamental rights then come into play immediately. Because by them coming under those articles in the Constitution, they must place before you what we call compelling reasons. Which I must say, they've actually failed to give you compelling reasons. This is a matter you're being told has been investigated in the United States of America. That is where the indictment has come from, and that is where the warrant has come from. But the state here is telling you they want to investigate these persons on issues to do with their computers, their phones, their place of residence, previous criminal records, and assets. It's clear in the affidavit. This is not what the Americans are coming to investigate here. It is the Kenyans who have taken up this matter and they're telling you they want to investigate. And now they are telling you, please place these persons in custody for the next 14 days. 14 days. To investigate what is not in their mandate. So what are they doing, Your Honor? They think that Article 19 should not come into play. Your Honor, Article 19, sub-article 3 is clear. These fundamental rights that are available to suspects belong to an individual and not, I repeat, not the state. Your Honor, Article 20 then comes into play. This is where we are enjoining that particular state, the prosecution, the officers who have arrested them and brought them here, and including the courts. Not that they are not alert. They are alert that these fundamental rights exist. But what is the next step? The next step is to ensure that these fundamental rights are enjoyed by the persons who have been brought to court. So if that is what they are supposed to ensure, what does that mean, Your Honor? It means that the courts and all these other institutions must want to start by wanting to grant or to allow the enjoyment of those fundamental rights. That is what they need to start with. But the state starts on the wrong foot and they tell you keep them for 14 days. But the court and everybody is bound by them. Not only are you aware of them, Article 21 shows that you are bound by them. So it clearly shows that these fundamental rights are not only for mere show, they are there to be effected. And that is why, Your Honor, will ask you, please look at Article 22. It is clear that the moment the state now wants to overstep or overreach by wanting to prevent these persons from enjoying their rights, Your Honor, we come to you under Article 22, Article 23, and Article 165 of the Constitution. Clearly, now they are overstepping and they want these persons in custody. Why am I saying this? Because they have not given you what we call compelling reasons. In their application, they say they want to go and look for, to go to their houses and do searches. It means they know that these people have a residence where they stay, and therefore, if they have a residence, they have a home where they can find them. Why is that important, Your Honor? Because we know where we can find them. They are telling you they want to go and conduct searches in that house and to gather documents. What the state is not telling you, and why I'm saying that they are coming with malicious intentions and dirty hands, is that they did these searches yesterday. They made inventories, and these inventories is what they are keeping away from us. I have asked the investigating officers twice this morning and the prosecution for those inventories. Your Honor, if they are denying to give us these inventories, you begin realizing that they are started with a process of unfairness. Why are they keeping them? Your Honor, if they want to go and search the houses of the respondents here, do they need to be in custody for them to go and search their houses? No. If they want to go and look into their phones and laptops, does it require that these persons be in custody? Again, no. The only thing that these persons can do is either they decide to keep quiet or say nothing, and Article 50 covers them fair and square. They also want to keep these persons in custody because they believe that these persons will abscond. Now, this is where it becomes tricky. The law is quite clear. In the case of Dwight Sagarai, again, I'll come back to that, versus Republic. In the case of Richard David Alden versus Republic. In the case of Oscar Sudi versus Republic. What did the courts say in all these matters? And it has never been challenged by any. For the state to say or allege that a person is a flight risk or might abscond, they must, Your Honor, and the word is must, place material before the court. Place material before the court to show that the respondents have attempted to abscond, have made preparations to abscond, bought tickets or consulted tour agents and travel agents. Those are the exact words. So what have they placed before you to show that they want to abscond, Your Honor? Today I will tell you, Your Honor, they have placed nothing. Let us go by nothing. That is the only thing they have said. And so what do they add about it? They tell you there is an Interpol notice, red alert. But Your Honor, so what? So what if it is there? It has been there since 2025, 2023. Or whatever period of time they say. Are they saying that the respondents were aware and were hiding? They cannot prove that, they have not shown that, and it cannot be true. If there is an Interpol notice, then where are they going to go to? Where are they going to go to? They cannot abscond from this country and go elsewhere because the notice is there. So the safeguards are there. Your Honor, have they told you that when they went to look for them, they were missing from their residential places? Again, no. They actually found them in their homes with their families. And that's where they did the search. At that particular time when they found them, these persons did not attempt to abscond. Did not. So, Your Honor, how is that ground compelling? In those authorities that I've quoted, it is said that the courts can put restrictions and conditions to ensure that these persons attend court. But Your Honor, remember, these people are not being charged here. They are not being charged here. But the state wants them in for 14 days to conduct further investigations. If they are not charged here, Your Honor, the court then can grant this bond to them. Your Honor, they cannot come to this court and ask for you to keep these persons in custody while they are discriminating. They decide that because it's going to be an extradition case, these people should not be granted bond. They should not. It's a clear contrast to what the Constitution says under Article 24 and 25. And if that can be allowed to even go for a minute, then that means you are also denying them their dignity. These are family persons. Peter was arrested right in front of his family. His wife, who is also present in court, was there. The children, there are 3 of them. The officers held them so indecently and so forcefully and without care for a person who was peaceful and was not doing anything wrong. Yet they come to this court and want you to grant them those orders when they are trampling on the orders and on the decency of the others. You know, you're being told that there is inter-border crossing and all that. And that these offenses were committed in the United States of America. You know, let me surprise you. These people have never been to the United States of America. You see them here. They have never been. Because if that was a fact, it would be on record here, showing that they traveled to the United States. And so when the extradition comes, we shall be opposing that extradition. But in the meantime, there is no proof that they have been in the United States of America and that they ran away from there. They are not fugitives, as the law would call them. They did not refuse to cooperate. They gave out the items that were required. In fact, the most shocking thing, they even took the first respondent's house girl who was employed in January. They took her phone also to investigate it for offenses that occurred in 2020 when she had not been employed. It shows malice. Taking the children's computers and all those other things, the birth certificates, the land title deeds, the cars, the logbooks. Why would they do such a thing if they are not malicious? They are not coming in good faith, Your Honor. And that is why these fundamental rights exist, so that you protect these people from such kind of persons. The first respondent has got a child who is 11 years old, suffering from cerebral palsy. The officers who went there also saw. He's the one who provides for that child. He's the one who takes care of that child. And as we keep on going for medical treatment and all that, he's the one who pays for it. They did not care about that. They took his ATM cards and took his money and took all the things that they had and did what? And blocked him from even accessing money that even the wife would have been given to take care of the child. If that is not inhumane, I don't know what else is. But still, without embarrassment, they come to you and tell you, give us these people for 14 days. If they want to deal with Safaricom and service providers, these gentlemen here do not work for those institutions. They do not work for those institutions. So therefore, they are not of any help. They are not going to print data for them. They are not going to do anything for them. Let us breathe some life into this constitution, because today, if you allow the state to do this, interfere in matters that have come from the US, and then they tell you keep these persons in custody, where do we head? And what they tell you is they are still waiting, waiting for the United States of America to bring what we call a bundle, the extradition documents, through what? Diplomatic channels. I have done quite a number of these extradition matters, Your Honor. Sometimes it takes ages. In the meantime, you are being told, keep them in custody as we wait for those documents. Till when, Your Honor? If and when they get that bundle or documents, then what will they do? Call us and we shall come. These people will be presented, Your Honor. They will come. Because even from the documents that you have here, nothing shows that these people have ever been called by anyone, Americans or Kenyans, to go to court or to appear anywhere. They have never been called. So the basis of saying that they will abscond or might not turn up and their flight risk cannot exist, Your Honor. They have never been called. If it is, I'm challenging the state. Please produce that. Show us that you have called them before. Let them show you, Your Honor. Let these respondents go home. They are fixable. Give us conditions to terms. Even that extradition act they are talking about, if you read from section 5 to 9 and to 11, jumping 10, there is provision for bond. Yet, when that matter, if at all it ever comes, shall also be granting bond. So what is the basis of denying it now? So if they have not interfered and they have not attempted to abscond, what else remains, Your Honor? What else can they tell you that is compelling right now? What else? This is the affidavit they have brought. It is sworn by an officer who I can assure you right now, Your Honor, has not even been to the United States of America.
I think, Your Honor, that's
No, it's
an
true.
unfair statement.
No, it's true.
No,
I asked him.
Withdraw.
I asked
Please
him.
withdraw that.
Your Honor, he has not actually. That's the truth. I even spoke to him and asked him. He told me he has never been to the United States. Okay, let me withdraw, but you know what's in my heart? Even Mr. Omari has not been, but
I can't afford.
And so therefore, Your Honor, the information that he is relying on is not because he went there and collected it, but because somebody has given him some papers that only have a warrant and an indictment. It is the promise of this respondent, and they are telling this court, and they are convincing this court, and they are promising this court Grant them bond, you can come back here after 14 days and see whether the state has anything. Grant them bond, and if the state does not have anything between 14 days, if they want any other date, we shall be able to appear. Grant them bond, in case the state has these documents by tomorrow, they shall appear by tomorrow. It isn't the best scenario tonight to deny them bond, Your Honor. That should be the last restrictive one. As Mr. Omari just adds up something, and I expect to sit.
Can be slapped hard. You know, this is a landmark decision that you'll be called to make a decision. Why I call it a landmark decision is that the state has come before you on the basis of a futuristic occurrence, that they don't have the extradition commit of bundles. They are waiting to be served. And they are seeking for 14 days?
14 days.
14 days. On a promise they have been told that is likely to mature. You know, first, there's no doubt that promise is going to come from the American government. That has been disclosed. That promise can only materialize, one, if Kenya has an extradition treaty valid with America. Is there one? A resounding answer, none. I'll be laying the basis. Two, that there must be an agreement between the two countries called a bilateral mutual agreement between Kenya and the US. Is it there? It does not exist. Your Honor, let me give you the historical basis of my argument. Is that in 1931, Kenya signed, that is the United States of America and the United Kingdom, on the 22nd day of December 1931, they signed a treaty for the reciprocal surrender of fugitives between the two nations and their respective territories. Kenya was a colony of the UK, and that treaty bound the Kenyan country. That was 1931. Many Kenyans were carried away, just like the Russians are carrying our ladies all over. Come 1963, Your Honor, when we get independence, the treaty did not automatically become binding upon Kenya becoming a republic. We changed the flag, we got our Kenya national flag. We became independent. Section 3 of the Extradition into bracket Contiguous and Foreign Countries Act, Cap 76, is the basis on which visa application is standing. Section 3, Your Honor, provides that extradition may only be permitted where a valid treaty or arrangement exists and has been duly applied by a legal notice. Your Honor, this is the Kenyan government speaking in 1963. The legal notice number 185 of 1969 was published on 19th December 1969. Your Honor, the legal notice declared Part 2 of the Act to apply to the United States and expressly referencing the 1931 treaty. The notice was intended as an interim measure. It was for an interim measure pending the conclusion of a new agreement. And it cannot be interpreted as adopting the 1931 treaty in perpetuity. Your Honor, subsequent international treaty agreements between the UK and USA has made that 1931 treaty defunct. In 1972, Your Honor, the treaty was signed, and in that treaty between America and UK, Kenya was not a party. UK and America also entered another treaty in 1985. And lastly, another treaty between the two countries was entered in 2003. Those are treaties between America and UK. Is there any valid treaty between Kenya and America? There is none. You know, let me move to the legal requirements and constitutional provisions Mr. Kinyanjui will deal with. Only extradition can be done when there is a valid treaty. It is not there. The state can provide that treaty. You know what I'm raising is a pure question of law. Can these people be withheld in custody on a charge not known in the Kenyan law? They can't. Based on that reality that there is no basis to make that application before this landed court, we submit that the two be released on favorable bond terms and cash bail until those documents are brought before you. The Kenyan Republic is not a banana republic where foreign powers come without lawful authority to take our citizens. You know, two, the manner of arrest contravenes the provisions of the Bill of Rights. The investigating officer took the medical records, the medical treatment records of the accused, the suspects. Why? If they wanted to do a DNA testing, they could have gone for the blood and the swab of the saliva, not medical reports. The suspects have their medical drugs here. They were picked. This is a clear indication these are patients with serious medical complications. For Peter Omari, not related to me, you know, interestingly, I have Nick Omari here, is contesting in LSK. We will elect you, boss.
Thank you.
You are a good advocate.
I appreciate it.
He shares the name with me. I have an accused person who also shares the name with me. He has medicine for disease that is called GARD. G-A-R-D. I don't want to, it's a serious heart condition and the intestines. As much as we be asking for bail, Your Honor, we shall be seeking that the court orders for them to be taken to hospital, regardless of the decision the court will make, for them to see their doctors and they be attended to. I'm also told Asanyo, the second respondent, is sick of diabetes, and we shall be seeking that the state surrenders the X-ray documents and medical treatment they have, so that whichever hospital they will go, they don't undergo a similar procedure again. You know, lastly, the question I want this court to be answered before this court is this. In the affidavit, an indictment has been attached from a court in the US. That court made a judgment that these people have committed offenses against the American law. They be extradited. What role does the DCI Kenya have in that matter? the role of the DCI is restricted to arrest. You know, I've forgotten the decision of the Supreme Court in a battle between the Office of the Attorney General and the DPP on the question who has jurisdiction to deal with matters. I've been told it's Gishuru and Okemo versus the Republic. Cliff has told me. The Supreme Court decision. The Supreme Court gave the ODPP that mandate. Extradition is not investigatory. And therefore, if the Supreme Court has given the ODPP that power to the exclusion of the National Police Service, the National Police Service cannot start claiming they want to investigate. You know, after the police are saying they want to investigate, where will they take the file for approval? Will they take the file to the office of the ODPP in the US?
If there is one there.
It is an absurdity that these people are going to be investigated here. And that is why, Your Honor, we are laying the basis that the DCI should only keep off. Their role was to arrest. The ODPP brings documents from the American government and presents before the court. The police role is left to providing a cell as a holding ground. This is a battle between the ODPP and the defense team. And therefore, you know, an application for custodial under Article 49 or under Section 36 of the CPC has no basis in law, because the DCI has no role in this matter. Your Honor, lastly, if I sit, is the question that has been brought before you that they have intelligence reports. The affidavit is called on intelligence reports. Extradition is not about intelligence reports. It is about evidence that has been gathered, presented before a competent court in any country. A decision has been made and an international warrant issued. The question of NIS coming to give intelligence reports or multi-agency teams in Kenya is not before this court. And neither during the extradition process will the police be called to as witnesses to testify, other than they'll only testify that they are arrested. So, Your Honor, we urge the court to reject this application on the basis of our PO and release the two on cash bail and terms until the treaty is presented before you. Thank you.